Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, we have what is called an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are referred to as your more petty offenses. Does not mean that they're not serious, it just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted. Now, felony cases are divided into 5 categories. So we'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 2 years to a minimum of 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000 if a person is convicted of a third-degree felony. The range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000 if a person is convicted of a second-degree felony. The range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000 if a person is convicted of a first-degree felony. The range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, misdemeanor cases are divided into 3 categories. And we'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanors are cases that start or originate in the city court or the JP court, Justice of the Peace Court. Now, those cases come to this court when a person is found guilty in either the JP court or the city court, and then they ask for a new trial and they want an appeal. In essence, they appeal the case and the case comes here and they get an automatic new trial. Now, the range of punishment is the same. It does not change. Now, for example, an example of a Class C misdemeanor will be speeding, or not having your seatbelt on, or having some type of violation with the sticker on your car. Those are Class C misdemeanors. And the range of punishment is fine only. In essence, you could be given a fine, but you cannot be given jail time. And the fine cannot be above or cannot exceed $500. So $0 to $500 for a Class C misdemeanor. Now, if you fail to pay the fine, or if your fine was converted to community service and you fail to perform the community service, then the court, the judge, can issue what is called a capious pro fine. What that means is the judge can issue a warrant for your arrest for you to either pay the fine or for you to sit the fine out in jail, in the county jail. Now, if you sit the fine out in jail, you'll be credited at $100 per day. Now, the next highest misdemeanor above the Class C is a Class B misdemeanor. And the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. An example of a class B misdemeanor will be like criminal trespass. You know, you own somebody's property, they told you not to own the property, they told you to leave, you refuse to leave. That would be a class B misdemeanor. Another example of a class B misdemeanor could be just a DWI first, your first DWI. When the blood test is less than 0.5, where your BAC, blood alcohol concentration, is less than 0.15. Okay, and so those are just examples of class B misdemeanors. Now, again, the range of punishment for class B misdemeanor, minimum 0 days to maximum 180 days, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, for class A misdemeanor, you know, class A misdemeanor will be like an assault. Okay, that's a good example of a class A misdemeanor, or DWI 7, or DWI with an alcohol concentration of 0.15 or more. Those are examples of class A misdemeanors. And when the range of punishment for class A misdemeanor is minimum 0 days to maximum 365 days in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation, and the other type of probation is called adjudicated probation. Now, the difference between the two is as follows. With the unadjudicated probation, it does not result in a conviction and record. And if you successfully complete it, the case will be dismissed, and you may qualify for what is called a non-disclosure. I'll explain to you what a non-disclosure is. A non-disclosure basically means that your record is sealed to the general public. The general public cannot have access to it. Okay? Now, the opposite word that I use is general public. And when I say general public, I'm talking about most of the public. Now, the government, certain government or agencies can have access. But most of the public is the general public, so they cannot have access. Okay? Like if you're working with, say, mobile phone, they can't have access. But the police department, whose government agency, can have access. All right. Now, the other type of probation is called adjudicated probation. With adjudicated probation, unlike unadjudicated probation, adjudicated probation, we normally refer to as regular probation, it does result in a conviction and record. However, there's something that is called judicial clemency. What that means is the court or the judge can set your conviction aside and you will no longer have a conviction. Now, in order to qualify, three things has to happen. One, you have to successfully complete the probation. Two, there cannot be any more time left on the probation. And three, the probation office has to successfully discharge you from the probation. If those three things happen, then the court, the judge that is, can have the judge has the discretion to set your conviction aside, and you will no longer have this conviction on your record. However, if you get another conviction later on, then the case that you received judicial clemency on can be brought back up. It could be resurrected, revived, and brought back up, and it could be used against you. So if you try to get a license with Child Protective Services, CPS, they can deny giving you a license. Or if you have a license with CPS, they can revoke or suspend your license. All right. Now, everyone here, for your case, you should have a clipboard. Who does not have a clipboard? Raise your hand. Okay? Hold on a minute. Yes. Okay. Well, did you tell her?
She's checking on.
Okay. Well, they're checking on. All right. So everyone in here should have a clipboard. I'm going to go over that clipboard with you right now. Make sure you turn to the first page. And we're gonna stay on that first page because before we leave, everyone is going to sign and initial this first page. Now, the first page, not the little bitty short page, it should be a page that looks like this and is titled Judge's Explanation of Rights to Defendants Without Attorney. Okay? This document talks about your right to have an attorney. Okay? And it states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first sentence under number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given a court date. To give you time to hire your attorney. The next paragraph, the next one sentence paragraph states that if you want an attorney but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And so you would have to first fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, the financial questionnaire is a 3-page document that is also on the clipboard. It is titled either Jefferson County Affidavit of Indigence or Affidavit of Indigence. Okay? You would have to fill out, now this is only for people who will be applying for a court-appointed attorney. If you are not applying for a court-appointed attorney, don't worry about this form. Okay? You want to hire your attorney, you don't have to worry about this form. If you want to represent yourself, you don't have to worry about this form. So if you would like to if you would like to apply for a court-appointed attorney, you will fill out the first page of of this document that's titled Affidavit of Indigence. And on the second page, you will fill out the top portion up here that is titled Defendant's Oath, and you will fill out the middle portion that is titled Unsworn Declaration by Defendant. Okay? And once you finish filling out the first page and these two locations on the second page, you stop. You don't have to fill out anything else. All right? Now, this is only for people who are applying for court-appointed attorney. Now, if we go back to this first document, the second paragraph, the third paragraph below number 3, this third one sentence paragraph, this is for individuals who will be representing themselves. Okay. As a defendant in a criminal case, you have a right to hire an attorney. You have a right to request a court-appointed attorney, or you have a right to represent yourself. That is, waive means to give up your right to have an attorney and to represent yourself. Now, if you're representing yourself, you are acting as your own attorney. Okay? And since you're acting as your own attorney, you can talk to the assistant criminal district attorneys about your case. Just like your lawyer, if you had a lawyer, would be able to do, because you are your own lawyer, you can talk to one of these two prosecutors. They're assistant criminal district attorneys. You can talk to them to see if y'all can work out a settlement in your case. We call that a plea bargain. Okay? Now, before you are able to talk to one of them, you have to first sign a waiver of your right to have an attorney. The waiver, for those now, this is only for individuals who will be representing themselves. If you're not representing yourself, you don't have to worry about what I'm saying. But if you want to represent yourself, then you would have to fill out this document, this waiver, that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding the trial. You have to read this document, sign and date it, and then you'll stop. Okay, now for those individuals who will be representing themselves, this paragraph that's in block form, the second to the last paragraph down here, states, be aware that the dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, this last paragraph here, before we get to the bottom, this last paragraph, one sentence paragraph, states, and this is for individuals who will be representing themselves. It states that if you desire to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you and the state, you want to work out, you represent yourself, and you want to see if you can get, let's say, probation, deferred probation or whatever. And you talk to the state, and the state said, well, I'll give you jail time. We offer jail time. You say, well, I don't want no jail time. Then you could tell the judge, well, I want a lawyer. You can change your mind about representing yourself, okay? That's just an example. So at any time, if you're representing yourself, you can request that an attorney be appointed to represent you. All right. Now, at the bottom of this document, it states defendant's choice. At the bottom in bold letters, it states defendant's choice. Mark initials next to only one choice. Okay, and you have 5 lines to the left. You can choose. Now, if you would like to hire your own attorney, you will place your initials on the first line to the left at the bottom. This is for individuals who like to hire their own attorney. Just place your initials on the first line to the left, and then you'll sign at the bottom and date it, and stop. And this is the only form you would have to sign if you're hiring your own attorney. Now, if you would like to apply for a court-appointed attorney, well, or if we're going on to the second, if you already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right, and then you'll sign, date it, and stop. And this is the only form that you would have to sign. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left at the bottom down here. The third line. Then you'll sign and date it. If you've already been appointed a court-appointed attorney, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right at the bottom. And then you'll sign and date it. Now, if you would like to waive your right to an attorney, which means to give up your right to have an attorney to represent you, and you would like to represent yourself, then you will place your initials on the fifth line to the left at the bottom, sign and date it, and that's it. Okay. Do we have any questions? Yes.
If I decide to represent myself, can you explain to me about that paragraph that says the loss of opportunity of employment and benefits?
These are the things that can be affected by you having a conviction. Example, it says, be aware that the dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Okay, those are consequences of convictions in one way or another. Okay, certain cases, you get convicted on, you can't, own or possess a firearm. Okay? Um, and see, if you live in public houses, maybe, when they go back and do criminal background checks, you may not qualify for public housing or certain benefits. Okay, that's basically what it's saying. You should be aware of that. Okay. Any other questions? Okay, so just as a brief recap, if you are hiring your own attorney, you only sign this form, sign dated, that's initial and date, that's it, and sign, okay. If you are applying for a court-appointed attorney, you're gonna sign, place your initials on the third line of this form, sign dated, and you're gonna fill out this affidavit, first page. And then on the second page, you got two locations. You're gonna fill out the top portion that's titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. If you are representing yourself, then you'll place your initials on the fifth line of the first document, sign and date it, and then you'll fill out the form, read it, and sign this form that is titled Waiver of Counsel for purposes of entering the guilty plea or proceeding in the trial. Okay. All right. So at this time, I'm going to move to, we're gonna give you time to fill out those forms. Okay, you don't have to fill those forms right now. I need to explain to you some of the other rights that you have. One of the rights that you have is the right to have a jury trial. For those young people are sitting in an area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence that's being presented by the state and the defense. They will listen to the arguments of the state and the defense. And then they will go back into the jury room and deliberate. And then they will decide whether to find you not guilty or guilty. You also have a right to waive, which means to give up your right to have a jury trial. Now, if you waive your right to have a jury trial, then you still can have a trial. It's a trial without a jury. We call that a bench trial. It's a trial by judge only, where the judge will be the judge and the jury in the case. The judge will listen to all of the evidence from the defense and from the state. The judge will listen to the arguments from the state and the defense. And then the judge will apply the facts to the law and decide whether to find you not guilty or guilty. You also have a right. Now you can enter one of three types of pleas. You can enter a plea of not guilty. If you enter a plea of not guilty, it's telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be contesting or you will not be fighting the charges against you. Now, if you enter a plea of guilty or no contest, and you would like to see if you can work out a plea bargain with the state, there are two types of plea bargains. And again, plea bargain means you're trying to work out a settlement of your case. One type of plea bargain is called agreed, that it's an agreed plea bargain. And that's because you and the state have agreed to the plea bargain. The other type of plea bargain is called unagreed plea bargain. In essence, you and the state have talked, but y'all cannot agree. You want probation, they want jail time. You don't want to agree to that. Okay, we call that unagreed. You still want to plead. Now, if you have an unagreed plea bargain, you can't reach an agreement with the state, then your case comes before the judge. And so the judge can decide what the punishment will be anywhere within the punishment range. And that is anywhere from a fine, jail time, fining, jail time, probation, either unadjudicated or adjudicated probation, okay? Now, if you and the state have agreed to a plea bargain, in essence, you want a probation, they offer you probation, that's just an example. Then your case will come before the judge, And the judge can do one of two things. The judge can accept the plea bargaining agreement or reject the plea bargaining agreement. If the judge rejects your plea bargaining agreement, you can say, well, judge, since you're not going along with the plea bargaining agreement that I made with the state, I take my plea back. And that's because I'm not pleading guilty of no contest. You have a right to do that. You can withdraw your plea if the judge does not follow your plea bargaining agreement. Now, however, if the judge does follow the plea bargaining agreement, that is, you want a probation, state gives you probation, everything is fine. And then within 30 days after pleading in the case, you decide, you know what, I think I've been wrongfully convicted, or the state or the court committed an error by convicting me. I would like to appeal my case. Now, if you come to the conclusion that you would like to appeal your case within a time frame in which you're allowed to make the request, you have to get permission from the judge that followed the plea bargaining agreement to appeal your case. And if the judge gives you permission to appeal your case will no longer be in this court. It's going to go to another court. And the court that it's going to go to is the Ninth Court of Appeals, which is right upstairs on the third floor, right above us. We right below the Ninth Court of Appeals. There are 4 justices up there. They will review your case. They can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty and your case is over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, you can appeal it to a higher court than them. You can appeal it to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeals. Now, you have to file what is called a pro se petition for discretionary review. I'll explain that to you. Pro se means that you represent yourself. Pro se. That's what pro se means. Petition for discretionary review, you're petitioning the Texas Court of Criminal Appeals to review your case. Why? To see whether or not your appeal should have been granted by the Ninth Court of Appeals, or to see if this court committed an error by convicting you. They can do one of two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty. Case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your petition, at that point, your conviction will stand. Okay. Now, another right that you have is a right to have witnesses to come to court. That chair that has the microphone in front of it, we call that the witness stand. And what witnesses do in a case, they testify. They can testify for you or against you. If you're representing yourself, you can ask a question. If you have a lawyer, your lawyer can ask them a question. We call that either direct examination or cross-examination. Now, you can waive or give up the right to have witnesses. That is, you have a right not to call witnesses. Now, just because you do not call witnesses does not mean the state or the district attorney would not be calling witnesses, because they will be calling witnesses in your case. Now, you also have what is called a Fifth Amendment right against self-incrimination. What that simply means is you have a right to remain silent. The state, the government, the district attorney's office cannot force you to take the witness stand and testify against yourself. And that is from the Fifth Amendment of the United States Constitution. I know a lot of times we watch television, we like Law and Order, and you might see the television lawyer goes up to the witness to ask a question, and the witness says, I take the fifth. What the person is saying, I'm exercising my Fifth Amendment right against self-incrimination, and I'm not saying nothing, and you can't make me say nothing. In essence, I have a right not to incriminate myself. So if you think about that for a minute, it makes sense. Why does it make sense? One, because the state of Texas or the government has the burden of proof. What burden of proof is? They have to prove beyond a reasonable doubt that you're guilty of the offense that you're charged with. You do not have to prove yourself guilty. Okay? That's their job. Okay, so that's why you have a Fifth Amendment right against self-incrimination. Okay. Now, you can waive or give up your Fifth Amendment right against self-incrimination. If you do that, that means that you will be taking a witness stand. Now, if you take the witness stand, obviously the state can ask you questions. Now, the other right that I'm going to talk about that you have is you have a right to have discovery. The word basically, from a legal sense, you have a right to see the evidence. That's what discovery means. The state has evidence. They have a file. Okay? They have evidence that they will be using. You have a right to have access to that evidence. In essence, you have a right to see witness statements, your statements, police reports, lab reports, photos, video recordings, listen to audio recordings. You have a right to see any type of instruments that they have, any type of documents. You have a right to have access to that. You have a right to see the evidence that they're going to be using against you. We call that discovery. Now, you also have a right to waive or give up your right to have discovery, which means that you don't have access to the evidence. All right. Now, everyone that's here today for a case, charges have been filed against you, you've been arrested, placed in jail, you bonded out of jail, you're out of jail on either what is called a cash bond, which means you pay the full amount of the bond to get out of jail, or you're out of jail on what we call a PR bond. PR bond means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance with a promise to appear today, or you may be out of jail on what we call a surety bond, which means that you pay a bondsman a percentage of the bond to get out of jail. Now, I said that to say this. Every day that you spent in jail, it can be used against you. Well, every day that you spent in jail, that jail time can be used in your case. Hold on a minute. Get it. Now, jail time can be used as credit in your case. So, for example, let's say, now every day that you spend in jail can be used as credit toward your punishment. The operative word is every day. Let's say you were arrested at 11:59. You was placed in jail at 11:59 p.m. last night, and you bonded out of jail at 12:01 a.m. this morning. In essence, you bonded out of jail 2 minutes later. Okay? We consider that 2 days. Why? Because it's 2 different days. So you was in jail 2 minutes, but you get credit for 2 days. And that's because you don't have to be in there 48 hours to get credit for 2 days. It's 2 different days. Okay? So every day that you spent in jail can be used as credit towards you. Let's say, for example, you spent 5 days in jail. And you talk to the state, and they're offering for you to serve 5 days in jail. That means you don't have to serve any more time in jail because you'll be given credit for the time that you've already served. Therefore, you'll be given credit for time served. That's what we call it. Now, if they're offering 7 days in jail and you have 5 days credit, that means you don't have to serve 2 days. Why? You already have 5. We'll subtract 5 from 7, that leaves 2. Now, Now, let's say the state is offering you a fine in this case. Now, every 1 day that you spend in jail, you receive $100 credit that can go toward your fine and court costs. So, for example, you spent 5 days in jail, okay? That's $500 that can be used towards your fine and court costs. So if the state is offering you a fine and court costs of $500, you don't have to pay anything if you spent 5 days in jail because the time you spent in jail has already paid it off. Now, if they're offering fine and court costs of $700, then that means you have to pay $200 because you already have $500 credit that we will take from the $700, that leaves $200. You'll be required to pay the remainder of the fine the day that you take care of the case. Now, if you can't pay it that day, no problem, because we could put you on what is called a payment claim. Okay? You can pay off in small monthly installments until it's paid. Now, let's say we put you on a payment plan, you still would not be able to pay it off, no problem. Because we could convert the fine and court costs to community service. And so for every 1 hour of community service that you perform at a nonprofit organization, you will receive $12.50 credit towards your fine and court costs. So for example, if you work 8 hours community service one day, that's $100 that can go toward your fine and court costs. Now, in our scenario, you work 2 8-hour days, and that will go toward your fine and court costs, and you'll be through. Now, Jefferson County has a program that is called pretrial diversion. It's for people, it's your first time having, many of been charged with a criminal offense, or one or more criminal offenses. With that program, they will dismiss your case and you can get it wiped off your record. Okay? And that's just through the district attorney's office. And so in order to qualify for the program, one, it has to be first time having cases or a case filed against you. Two, you have to have an attorney to just assist you with the application process. And three, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. So for all other charges, you may qualify. If you are a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. It's for veterans only. With that program, you get in the program, complete the program, they will dismiss your case. And you may qualify for a non-disclosure, whereby your record is sealed to the general public. Now, this court, County Court at Law Number 2, Jefferson County, Texas, has a program that God led me to start within the first 100 days of me taking office in March of 2017. That's when the program started. The program is called the CSI program. CSI is an acronym that stands for Community Safety Initiative. With that program, the program is designed to address the issue of what we call recidivism. Recidivism means how do we, people commit crimes over and over, recidivism, they call it. And so how do we address it? We address it through our Community Safety Initiative. And with the Community Safety Initiative, we have partnerships with various agencies in our area. One of the agencies that we have a partnership with is Spindletop Center. Spindletop Center is our local mental health center in the Southeast Texas region. And we have folks from Spindletop who's going to come to you and talk to you in a few minutes about their program. But basically, what Spindletop will do, they can have a private interview either in our jury room at their facility or by telephone, whichever is convenient for you. Then they can do an assessment. You know, assessment means they can determine what your mental health problem may be. And then 3, they can develop a treatment plan for either outpatient or inpatient treatment. Now, in order to qualify for the program, you do not have to be insane. You do not have to be incompetent. You could just merely suffer from depression, anxiety, or any other host of mental illness. They have the expertise to address your mental health needs. If you have issues with alcohol or drugs, well, Spinotop has a program that's called ATAR, ATAR, which is an acronym that stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. With those programs, they can do an assessment, well, they can do a screening, and then an assessment to determine what your alcohol, drug issues may be. And then they can develop a treatment plan, either for outpatient or inpatient treatment. If you are unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. It's an acronym that stands for Center, Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. Now, all of these programs that I just mentioned does not cost you, they're free. It does not cost you anything but time. And I like to say in this court, we don't just give time. We take our time. That simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to county court at law number 2 of Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And we'll be happy to get you started on the journey that will change your life. And so at this time, we have our folks from Spinotop. We have our mental health deputy, Deputy DeVille. He's gonna come with Caitlin, and who's from Spinotop. And they're going to tell you a little bit more about the program that Spinotop has to offer.
Okay, she in here messing up already. How y'all doing today? I doing all right? Hey, Yankee and cool. I think Kathy Powell, was Tony Tom, I did a little bit of history on it. 8, 9 years ago, there's a lot of awesome crisis. So we came up with Spinotop partnership. The right partners are right together, eat together, and all day long. Right? Yeah. Our job, as no one else said, we want to do it's not into this time. 2, have hospital and science. So. I probably. Job as a health. You know, thinking about when you do 25 years ago, garbage size. Yeah. Just make it hard. That's the other reason. I go over this. Those sheet that was on top. Of the take one. Have sheet, you don't know that sheet. Again. That sheet, right there, option. You don't have to fill it out. But then you tell us, say, we know. Back if I hit them. I'm talking, you know, with the judge and anything like that, or. They didn't be here. Agent officer, be ready, say, well, that's. What you have to see.
Majority of the form is pretty self-explanatory. In the section where it's resources that you need assistance with, whatever you check, I will email you a form or a website that you have to fill out yourself so you can receive that resource. If you were to check mental health, which could be depression, anxiety, or PTSD, or substance use, which could be any type of drug, or alcohol, then we can help you get into spinal tap services or any services within the area. It doesn't have to be spinal tap. And that will include doctors, appointments, get medication for your mental health, if that's something you're interested in. Counseling, talking to somebody, support groups for substance use, support classes for substance use. And anything that you can think of, we can try to help you find a resource for it. There's no guarantee, but we will reach out and try to help you find it. If you'd like to talk to me in person today about mental health or substance use, you need to write on your paper, please talk to me today. And when the judge is done with you, I'll come and get you, put you to a back room, or we can talk privately. If you're so interested in mental health or substance use, but you don't want to talk today, you can check the call box and I'll call you within the week and we can talk about it. If you have any questions, you can call me. I'll call you and you can ask your questions. You can ask me your questions now, or when we come around and pick up papers, you can ask them.
And if I can, have I'll be dismissed. So when I'm talking to. Just hold off out the door. Stop waiting for it.
Thank you. At this time, we're gonna have Mr. Janice Stewart, he's with Family Services. They have a program that is called BIP, that is Intervention and Prevention Program. That's for individuals who have family assault cases. It's a program. You get into the program, they will give you help that you need once you complete the program. The case will be dismissed. You can get it expunged from your record. That means that it could be wiped off or deleted. Like it never has. So at this time, we're gonna have Mr. Johnny Stewart with Family Services.
Thank you, Judge.
You are.
Good morning. I'm Johnny Stewart. I'm the Batterers Intervention and Prevention Director for Family Services. You may know Family Services because of our Women's and Children's Shelter, but we also provide services for those first time family assault charge. This is it's an 18-week program, 2 hours per group, 1 class per week. We have Zoom classes for those who work, and we also have in-person classes at our office. This program is about, like the judge was saying, it's about changing behaviors. It's about changing those behaviors so you can not only help yourself, but help your family, and also prevent yourself from coming back into these courts. So take advantage of this program. We have some flyers over here. I'll put a couple more out there. So if you're a first time family violence charge, you're eligible for this program. And I encourage you to take advantage of this so we can work on changing behaviors. Thank you for listening. Thank you,
Okay,
Judge.
thank you, Mr. Stewart. Next, we will have Mr. David Cook, he's with Texas Care, and he'll tell you about the program that Texas Care has to offer to you. So at this time, Mr. Cook. You are.
Good morning. My name is David Cook. I'm a peer support specialist for Texas Care. And I'm doing outreach. Texas Care kind of falls alongside Spindle Top. We offer some of the same services, but we use Spindle Top a lot. They're very helpful. We have mobile QMHPs, which are qualified mental health professional. And we also work with children, ages 3 to 17. And, I've been a part of this program and it's been amazing. I've actually been where y'all are sitting. I didn't have these opportunities, so it's kind of neat that the court offers, these opportunities. And I was, super excited to be a part of it, knowing that mental health is at the forefront in the court. We offer crisis intervention, skills training and development, targeted case management, individual therapy, and evaluations and assessments, and we also do telehealth. But, I have some flyers over there as well, and on the clipboard, there's a form, you can fill it out, and if you need to see me today, I will be here. So, yeah, if you have any questions, I'll be here. Thanks.
Okay, thank you, Mr. Cook. Now, ladies and gentlemen, we're gonna give you the opportunity to finish filling out this paperwork. If you need help with filling out the paperwork, we have our court personnel who's here who will be happy to help you, including myself. Once you finish filling out the paperwork, we're going to pick that paperwork up from you. And we're gonna put you into one of 3 categories. One category, you wanna hire an attorney. Second category is you wanna see if you qualify for a court-appointed attorney. And the third one is you want to represent yourself. That is, you want like the way you like the attorney represent yourself. Now, it's gonna take us a little time to get all the paperwork up from everyone. Once it's completed. And then if you need to use the restroom, there are 2 restrooms right out in the hall. The men's restroom is in front of County Court at law number 3. And the female restroom, female restroom is on the opposite side of the hall. In front of the 172nd District Court. You'll be allowed to go out into the hallway to use the restroom. And then when you finish using the restroom, please come back into the courtroom. Now, please do not leave the courthouse. If you leave the courthouse, your name is called. Your bond will be forfeited. And a warrant will be issued for your arrest. And at some point, you will be arrested. Placed in jail, bond out, and guess what? You're gonna have to go through this thing all over again. Okay, so it's only gonna take us just a few minutes to get everything done, so just be a little bit patient with us. Again, if you need help, just raise your hand, and we'll be able to come out, have you come up so that we can assist you. So at this time, the court will be in recess. Be mindful that we're still in court. Even though the court is in recess, that does not mean we gotta get loud in here or anything of that nature. So just make sure you conduct yourself accordingly. Okay? So at this time, the court will be in recess. Ms. Hawkins. Could take your mic off of mute. Ms. Hawkins, you could take your mic off of mute. Yeah, Ms. Hawkins.
Yes, sir, I'm here. I'm sorry, I couldn't, it wasn't letting me unmute it.
Okay, now, Ms. Hawkins, well, your case is gonna be reset.
Reset?
Yeah, because you have to be here in person to fill out the paperwork.
Okay,
Okay, so we're gonna, now, we can put it on a Tuesday, or we can put it on a Monday, Wednesday, or Friday.
a Wednesday is great.
Okay, hold on a minute. Yeah, 2 weeks be fine. Well, are you available in 2 weeks?
Yes, sir.
Okay, so we're gonna reset it and, yeah, do that. Okay, this case will be reset to October the 8th at 9 a.m. And you need to be in court in person.
Yes, sir, I will be there.
All right, yeah,
Okay,
stay in contact with your bondsman. You're free to go. And again, court starts at 9 a.m., October the 8th, 2025.
okay, thank you so much.
All right, you're free to go and you have a blessed day.
Same to you, thank you.
You're welcome. Jefferson County Court, Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 25 CCCR 1860. Case of style, the state of Texas versus Emmanuel Carrillo Taruca. Mr. Carrillo Taruca speaks Spanish. We have Ms. Jennifer Raji, who is our translator. Ms. Raji, would you please raise your right hand? You swear affirm to interpret Spanish to English and English to Spanish to help you God?
Yes, sir.
Okay, you may put your hand down. How are you doing, Mr. Raji?
Good, Judge. Thanks for asking. How are you?
I'm doing fine, thanks for asking. And Mr. Carrillo Taruca, ask me if his full name is Emmanuel Carrillo Taruco. Okay,
Yes, Judge.
ask him to raise his right hand. Okay, Mr. Carrillo Taruco, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, tell him he can put his hand down. Okay, ask him how he's doing.
Good.
He's doing good? Okay. Now, Mr. Carrillo Taruca, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. Ask him if he recognizes this document.
Yes.
Is this his signature on the line that's titled Defendant?
Yes, Judge.
And are these his initials on the line that state he'd like to apply for a court-appointed attorney?
Yes, Judge.
I have another document that's titled Affidavit of Indigence. Ask him if he recognizes this document.
Yes,
And ask him if this is his signature on the line that's titled Defender Signature.
yes, Judge.
Now, Mr. Carrillo Taruca, before you sign any initial these documents, did Miss Jennifer Raji go over these documents with you in Spanish?
Yes.
Yes, okay. Ask him if he understood everything that you went over with it.
No. No te querías aplicar para el abogado. Sí, sí. Yes, Judge.
Okay. Ask him if everything in these documents is true and correct to the best of his knowledge.
Yes, Judge.
Okay. Mr. Carrillo Taruca, I read your answers, and based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Charles Rojas. Let him know that Mr. Rojas speaks Spanish as well. Okay, you can tell him he can stand before the court coordinator in this case to be reset. Let him know that Mr. Rojas is gonna be given information to contact him. And he'll be given information to contact Mr. Rojas. You need to fill out. They need to fill out the middle portion right here. Declaration. And he's gonna have to fill out this middle portion when he gets over there. All right, thank you, Mr. Roger. Tell Mr. Rillo Tarifa, have a blessed day. Christian Rubio. Mr. Rubio. Your full name is Christian Cloven Rubio?
Yes.
Mr. Rubio, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Rubio, you may put your hand down. How are you doing, Mr. Rubio?
I'm good. How about you?
I'm doing fine, thanks for asking. Now, Mr. Rubio, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes,
Are these your initials on the line that
yes.
state you would like to have your case reset to hire your own attorney? Before you sign any initial to this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Mr. Rubio, your case is going to be reset to give you an opportunity to hire your attorney. Our court coordinator is going to reset your case. Once your case is reset, you're free to go, and you have a blessed day.
Thank you.
Please have a seat in that first chair on the wall. Lariel Devon Rogo. Mr. Rugo, your full name is Lariel Devon Rugo?
Rougeau.
Rougeau.
Yes, sir.
Okay. Mr. Rougeau, would you please raise your right hand? Mr. Rougeau, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Rougeau, you may put your hand down. How are you doing? I'm doing fine, thanks for asking. I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Sir.
And is this your signature on the line that's titled Defendant?
Correct.
Now, Mr. Rougeau, before you signed and initialed this document, did you read the document?
Yes, I did.
Did you understand what you read?
Yes, I did.
Is everything in this document true and correct to the best of your knowledge? Okay, Mr. Rougeau, your case is going to be reset to give you an opportunity to hire your attorney. Our court coordinator is going to reset your case. Once you reset your case, you'll be free to go and you have a blessed day. Please have a seat on the second chair on the wall. Jonathan Smith. Mr. Smith, your full name is Jonathan Jamarcus Smith. Mr. Smith, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Smith, you may put your hand down. How are you doing, Mr. Smith? That's good. Now, Mr. Smith, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you've hired attorney Scott Rennick? Now, before you sign any initial to this document, did you read the document?
Sorry.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay. Mr. Smith, your case is going to be reset to give Mr. Scott Rennick an opportunity to send in his letter of representation. And our court coordinator is going to reset your case. Once you reset your case, you'll be free to go and you have a blessed day. Please have a seat in the third chair on the wall.
Rubio.
Lisa Ann Kohler. This is cause number 25 CCCR 1826. Case is styled the state of Texas versus Lisa Ann Kohler. Ms. Kohler, is that your full name?
Yes, sir.
Ms. Kohler, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Kohler, you may put your hand down. How are you doing, Ms. Kohler? I'm doing fine, thanks for asking. Ms. Kohler, I have before me a document that is titled Judge's Explanation of Defendants Without an Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yeah.
And are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there are a set of, there's a signature on the line that's titled Defendant Signature. Is this your signature?
Yes.
Okay, Ms. Kohler, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct
Yeah.
to the best of your knowledge?
Yeah.
Ms. Kohler, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in your case is Attorney Marcus Wilkerson. Attorney Wilkerson will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
We have a reference.
Thank you. Denard Mitchell, Ms. Mitchell, how do you pronounce your first name?
Danya.
Danielle. Okay, Ms. Mitchell, would you please raise your right hand? Ms. Mitchell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Mitchell, you may put your hand down. How are you doing, Ms. Mitchell? I'm doing fine, thanks for asking. Now, Ms. Mitchell, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes.
Now, Ms. Mitchell, before you sign and initial these documents that I just showed you, did you read the documents?
Yes.
And did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Mitchell. I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Langston Adams. Attorney Adams will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in the second chair on the wall. Thank you. You know what? I got some bond conditions I need to give her. I need to give you some bond conditions.
Yes, sir.
Okay. Okay, Ms. Mitchell, you just been handed a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you. And this document states that as a following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Mhm.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yeah.
And condition number 4 does not apply. However, on page 2, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is as defined in section 1.07 of the Penal Code, unless the defendant is actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, if you violate any one of these conditions, the bond can be revoked.
How was that? I
Uh,
can't just have one in my possession right now.
it says,
I'm just making sure that I do.
okay, let's read it again. The defendant is prohibited from possessing a firearm or ammunition. Okay,
But if they.
unless you say possessing a firearm, it says possessing.
That's what I'm trying
I mean, a person can own one, but if it's not in their possession, you're fine.
Okay, so in public, I can have.
You can't have possession.
Well, that's in public, right? Or is that period in home?
That's, you can't have possession of a firearm,
Okay, thank you.
okay? Unless you're as a peace officer as defined by section 1.07, Penal Code actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Okay,
That's fine.
okay, just have a seat and wait for your name to be called. Okay, Thaddeus Rito. Mr. Rito. Your full name is Thaddeus Jamal Rito? Okay, Mr. Rito, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Rito, you may put your hand down. How are you doing, Mr. Rito? I'm doing fine, thanks for asking. Now, Mr. Rito, I have two documents before me. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? Or these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant. Signature. Is this your signature?
Yes, sir.
Now, Mr. Rito, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Rito, looking at your application, I don't think you qualify to have a court-appointed attorney. Okay?
Yes, sir.
So, since you do not qualify for a court-appointed attorney, you have two options. You could, hire your own attorney. That's one option. And the second option is you can waive your right to an attorney and represent yourself. Okay. Now, I'm going to get his document back, get these documents back to the bailiff. She's going to, you can have a seat at that table. Yeah, and you can make your choice and then we'll call you back up. Darrell Ardwine. Mr. Ardwine, your full name is Darrell Ardwine?
Yes, sir.
Mr. Ardwine, would you please raise your right hand? Mr. Ardwine, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Ardwine, you may put your hand down. How are you doing, Mr. Ardwine? I'm doing fine, thanks for asking. And Mr. Ardwine, I have before me a document that is titled Judge's explanation of rights to defendants without attorney, you recognize this document? Is this your signature on the line that's titled defendant?
Yeah.
And are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yeah.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this document, there's a signature above the line that is titled defendant. Signature, is this your signature? Now, Mr. Ardoin, before you sign and initial these documents, did you read the documents? Do you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Now, Mr. Ardoin, I read your answers. Based on your answers, you do not meet the eligibility requirements for the appointment of a court-appointed attorney. And so you still have an option to either hire an attorney or you can waive your right to an attorney and represent yourself. I'm going to give these documents back to the bailiff. She'll give it to you. You can have a seat at that table and you can make your choice. Where's the Miss you have to start going to bed early, Mr. Cook. Can't be up all night.
No, sir.
Okay. This is cause number 25 CCCR 1812. Case is style of state of Texas versus Arthur Harvey Cook.
Yes, sir.
How you doing, Mr. Cook?
Miss.
And that's your full name?
Cool.
Oh, okay. Yeah, I see that. Okay, yeah, just a second.
Yes.
Okay, Mr. Cook, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Cook, you may put your hand down. Now, Mr. Cook. Okay, now, Mr. Cook, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's
Yes,
titled
it is.
defendant? Are these your initials on the line
Yes, sir.
that state you would like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2 of this same document, there's a signature above the line that's titled Defendant Signatures. That's your signature.
Yes.
Now, Mr. Cook, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your
Yes,
knowledge?
sir.
Okay, Mr. Cook, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Don Boudreaux. Donald Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Now, before we do that, Mr. Cook, let me do this here. Mr. Cook, why don't you stand right here? Okay, so again, you'll be appointed Don Boudreaux to represent you as your attorney. Now, Mr. Cook, you're gonna have a seat in that first chair on the wall, right there, and wait for your name to be called.
Yes.
And once your name is called, you go to the window. Once you finish, you'll be free to go. Well, we might just, once you finish, you want to just have a seat.
Yes.
Okay,
Thank you.
you're welcome. There you go. It's Don Boudreaux. We have any, okay. Mr. Rito? Hold on a minute, hold on. Okay, Mr. Rito. I have two documents before, well, actually, two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you'd like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver Counsel for purposes of entering guilty plea or proceeding to trial. And you recognize this document? And is this your signature on the line that's titled Defendant? Now, Mr. Rito, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Rito, just have a seat and one of the prosecutors will talk to you. Okay. You can get that to.
No relative, no. Okay.
Darryl Ardwine. Mr. Ardwine, I have these two documents, well, this document before me. It's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line state you like to have your case reset to hire your own attorney? I also have another document that is titled Jefferson, well, now, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Mr. Ardwine, your case is going to be reset, but before your case is reset, I need to give you some bond conditions. The bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Now, Mr. Ardwine, do you see that document? I'm going to go over this document with you, and it states following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Now, condition number 4 does not apply. However, condition number 5 and 7 does apply. And on the next page, condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Okay. And condition number 7, the defendant shall wear a global positioning monitoring system device at defendant's expense with written verification being submitted to the court within 3 days. You understand that condition?
Yeah.
Okay, now if you violate any one of these conditions, your bond can be revoked. If your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County Jail. You will get your reset, and you can get the information on where you can get the GPS from the coordinator. Just have a seat at that second chair. May Patel. Mr. Patel,
Yes, sir.
your full name is May Patel.
Yes, sir.
Mr. Patel, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Patel, you may put your hand down. How are you doing, Mr. Patel?
I'm all right. What about you, sir?
I'm doing fine. Thanks for
Okay.
asking. Now, Mr. Patel, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd
Yes, sir.
like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Mr. Patel, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
You explained very well before you,
Okay,
I see the first time for the judge, okay, who is explaining all the people.
okay,
That's a nice.
okay, that's good. So you understood everything I explained?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Oh, I need a back, I don't have a back page to. No, not you.
Oh, okay, okay.
You was talking to her.
I was talking, okay.
No, I was talking to her. I was on the, affidavit, yeah, that. What's up? It's not in there, paperwork. He didn't qualify for,
He didn't.
One of the jury, he explained all the people.
okay, this is, Patel. Hold on, just, I'll take a look in a few minutes. Okay, now, Mr. Patel,
Uh-huh.
I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that is appointed to represent you is Attorney Christy Carlton. Attorney Carlton will be given information to contact you, and you will be given information to contact her.
Okay,
Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that first, yes.
I'm requesting to the court, okay, I'm from Houston. If it is possible, sir, I can next court date, okay, maybe I can go via online, like.
Yeah, you have
because
the
of-
option.
I'm
I
from
understand,
Houston,
that's not a problem. We have,
and my driving license is suspended.
Okay.
So I'm
Okay.
not able to drive.
okay, that's fine. So, you'll talk to your attorney.
Okay,
They will also, our court coordinator will give you the Zoom phone number
perfect,
so
sir.
that you can Zoom in, but make sure you contact your attorney.
Sure, sir,
And your attorney is gonna be contacting you within 24 hours.
within 24 hours. Okay.
Yes,
Okay,
all right? There you go. Don't
Thank you, sir.
contact
Thank
your
you, sir.
attorney right now. He'll contact you she'll contact you within 24 hours.
sure, sir.
Okay, just have a seat in that first chair on the wall and wait for your name to be
Thank you
called.
so much, sir.
You're welcome. And it states that standard bond conditions in County Court at Law Number 2, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or other United States. Do you understand that condition? You can't break the law while you're on bond.
Oh, okay.
Okay. Number 2,
Mhm.
defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke your bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
So, no alcohol. I'm sorry, my English is little poor. I'm
Okay.
trying to, okay.
Okay, good. And number three, that does not, it doesn't apply. But number four does apply.
Mhm.
And number four states that, and this is for you, it says that a defendant whose information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. DWI second is listed under section 4904 through 4906 of the Texas Penal Code. Do you understand that?
So, I don't have.
Okay, just listen. Your offense is listed in this section, and because it is listed in this section, you shall not operate any motor vehicle
Okay,
unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court within on or before 3 days. So basically what this means, that if you own or operate any vehicle, that vehicle must have an interlock device on it
okay,
before you can drive it,
yeah.
okay?
Oh, after all, my driving license is.
So you don't
suspended
have,
for 1
so,
year.
so you say you don't have a vehicle, you're not driving, okay, good. But if you drive a vehicle, that device need to be on it,
Oh, sure.
okay? Now,
But how long?
until this case is resolved.
Okay.
Okay, now, defendants shall obtain, maintain, and pay for, and have no violations with the interlock device, mobile birth device. Any violation will be grounds for revocation. In essence, if you violate, if you have a violation, if you had an interlock on the car and you violated it, well, put it like this here. If you drove a car without an interlock, that's a violation of your conditions of bond. Or if you had an interlock on it and the breath detected alcohol on your breath and the device detected alcohol on your breath, that will be a violation. And if you have any violations, your bond can be revoked. You could be kicked off a bond and placed in jail. Do you understand?
No, I don't wanna go in jail.
Okay. All right. Now, the next condition, condition number 6. Defendant must attend AANA meetings 3 times a week.
Sorry?
You must attend, there's a group called AANA, Alcoholic Anonymous and Narcotic Anonymous. You must attend that 3 times a week and provide proof to the court.
Sure, sir.
Okay, now I'm going to give you a form. Now you say you live in Houston, right?
Yes, sir.
So I'm gonna give you a form. I'm gonna give you 2 forms that you need to bring with you every time that you go to a. Where's the?
AA and what is the NA?
It is Narcotics Anonymous. That's what just. I don't have
Narcotic.
Oh. So I have to do it both or?
No, they just name it that. That's just the name of the program.
Okay.
Where is, I don't have a sign-in sheet.
Sign-in sheet.
Corella. I know, I must be out of my, I don't have a sign-in sheet for, AANA meetings. Somebody took the last one? Yeah. Okay, just have a seat. We're gonna, they're gonna see if they can find, the sign-in sheet that you need to bring with you when you go to AANA meetings. And then every time that you come to court, you need to bring that form with those signatures on it back to court so that we can verify.
So I have to go over there, or it's gonna be online program?
They may have online programs as well. You would have to talk to a AA, you'll have to call and find out,
Sure, sir.
okay?
If it is good, if I go for online and tell them to give me email.
Okay, well,
So I will
yeah, however they
submit
do it.
it to email.
Okay, however they do it. That-
Uh, sorry.
If it's in person or if they can do it online, I don't know how it works.
Last time when I took AA classes, okay, all the time the meeting gonna be finished, okay. Whoever the leader, they send me an email.
Okay,
for,
that's right.
For like I.
That you attended,
Yeah.
right? I understand.
So I will send you emails.
Huh? Yeah. When you okay, you can get that to him.
Because of sometimes it happened like not go physically over there. So
Okay.
it's via online. I can do it.
Okay, that's fine. All right, so that's the form that you need to have, and you need to bring that form every time you come into court, or whatever they give you to verify that you are attending. Okay?
Okay.
All right,
And,
just
just give me the sorry, email address. So I
no,
can,
no, no. I only have addresses for this.
You want to
email
email it back.
Oh,
email
no, no,
address.
you're talking about the Zoom. For
No,
here?
yeah, but when I finish the class,
Okay.
so I have to send you email for verification forward message.
Okay, if you want to do that, that's fine. Okay. They'll give it to you.
Sure.
All right, just have a
Sure.
seat.
Thank you.
Okay.
You have a
Need to
seat in that
email
first
address.
chair.
Javante Howard? Mr. Howard, your full name is Javante Malik Howard.
Yes, sir.
So Howard, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Mr. Howard, you may put your hand down. How are you doing, Mr. Howard? I'm doing fine, thanks for asking, Mr. Howard. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendant's Wild Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indians. You recognize this document?
Mhm.
And on page 2 of this document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Okay.
Mr. Howard, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Howard, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that second chair and wait for your name to be called. You're welcome. Dylan Lawless. Mr. Lawless, your full name is Dylan Taylor Lawless?
Yes, sir.
Mrs. Lawless, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Lawless, you may put your hand down. How are you doing, Mr. Lawless?
Good, how you doing?
I'm doing fine, thanks for asking. Mr. Lawless, I have before me a document that is titled Judge's Explanation of Rights to Defend us while Attorney. You recognize this document? On the next document, there's do you recognize this document, Judge's Explanation? Okay, this is the Jefferson County Affidavit of Indigence, and on page 2 of this document, there's a signature above the line that's titled Defender Signature. Is this your signature? Now, Mr. Lawless, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Hey, Mr. Lawless, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you, will give you his information. And once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in the third chair on the wall.
If you wait on 384.
You can stay right there on stage.
384,
You can stay right.
on stage.
This is the email address, and it's just resuming my email. And hold on 1 second. Wait.
Amanda Lynn Libby.
Leave the earth on the table.
There's a full email address?
Yeah, all of that. I didn't have enough room, so add, and all of that.
Oh, these are the tag, right?
The at sign.
Your last name is pronounced, did I pronounce it right, Libby?
Levy. Levy.
Libby?
Yes, sir.
Okay.
I take a picture, maybe if I lose it, so I can save it.
All right, this is your court appointed attorney. This your court appointed attorney, Mr. Copeland. Your next court date is October 24th at 9 a.m. And this is your attorney.
Did you give him a Zoom number?
So, I will go for Zoom, right?
Yeah. Talk with your attorney first. If you're not gonna appear on that day, you can appear via Zoom.
Okay, okay,
There you go.
thank you so much. Thank you,
Oh,
sir.
okay, you're welcome. This is cause number 25 CCCR 1824 and cause number 25 CCCR 1825. Both cases are styled the state of Texas versus Amanda Levy. Ms. Levy, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Okay, Ms. Levy, you may put your hand down. How are you doing, Ms. Levy? I'm doing fine, thanks for asking. Now, Ms. Levy, the state is represented in this case by Attorney Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
Okay. Now, Ms. Levy, before we get started, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes, sir.
Okay, now, Ms. Levy, in cause number 25 CCCR 1824, I have before me a document that is titled information. Okay, in this information, Ms. Levy, it alleges that you, Amanda Lynn Levy, on or about May 13th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failed to identify fugitive with intent to give false information. Ms. Levy, do you understand what you have been charged with? To this charge, how do you plead? Guilty, not guilty, no contest?
Okay.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Levy, I also have a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials, 2 sets of initials. First set of initials is on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials there? Second set of initials is on a line that state, I do not wish to have discovery. I waive my right to discover in this case and choose to enter or plead guilty and no contest. Did you place your initials in this location?
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box is checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Ms. Levy, I also have a document on paper that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
And are these your initials on the line that states you like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yeah.
Now, Ms. Levy, before you sign and initialed all the documents that I just showed you, all these documents that I just showed you, did you read these documents? Did you understand what you read?
Yeah.
And is everything in these documents true and correct to the best of your knowledge?
Yeah.
Ms. Levy, are you a citizen of the United States?
Take over State Exhibit 1.
Ms. Levy, the state is offering State's Exhibit Number 1 to be used as evidence against you in your case. State's Exhibit Number 1 is the first document that we went over in the tablet. This is the same document that have your initials in these 2 locations on page 2, and it has your signature at the top of this document on page 3. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objections. State's Exhibit Number 1 will be admitted. Ms. Levy, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Ms. Levy, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we'd ask the court for 12 months of deferred adjudication with a fine of $300, repayment of court costs, and 40 hours of community service. Ms. Levy has 1 day jail credit to go towards the fine and court costs. And we also ask that this sentence run concurrent with the companion case 25 CCCR 1825.
We got 1 day's credit. What's the court cost? Okay, Ms. Levy. The state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. Your total fine and court costs is $577. You will be given 1 day credit toward that, so that will be reduced by $100. So your fine and court cost is $477. You also be required to pay a probation fee of $60 a month, urinalysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $127 a month. Will you be able to pay the $127 each month?
About bills, can we lower it?
Okay, so you made an affidavit, hold on a minute. Okay, so. Okay, now, Ms. Levy, I have before me a document that is titled Jefferson County Affidavit of Indigence. Sure, I'm gonna have to. And do you recognize this document?
I do.
On page 2 of this same document, there are a set of initials on a line. Well, there's a signature on a line that's titled defendant signature. Is this your signature?
Yes, sir.
Now, Ms. Levy, before you sign this document, did you read the document? This document here that you filled out,
Yes, sir.
did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Ms. Levy, the court is gonna find that you're indigent. And I'll explain that to you in a minute. So we make some adjustments.
Mhm.
Okay, let's see.
He'll go on.
It's 300. Okay. Ms. Levy, the state is offering that you serve 1 year deferred adjudicated probation. And the court is gonna find that you're indigent based on the finding of indigency. The fine in this case is $300 and court cost is $277, which comes to a total of $577. You have 1 day credit that will go toward it, which would leave $477. That $477 will be converted to 38 hours of community service pursuant to Article 42.15 of the Texas Code of Criminal Procedure. The probation fee in this case of $60 a month will be reduced to the statutory minimum of $25 a month. And you'll also be required to pay a urinalysis fee of $15 a month. The reimbursement fee of $15 will be waived, which means you will not have to pay it. And that's pursuant to Article 102.018 of the Texas Code of Criminal Procedure. And so therefore, your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $44 a month.
Yes,
Will you be able to pay the $44 each month?
yes, sir.
Okay. You will also be required to perform 40 hours of community service. Now, this 40 hours of community service is in addition to the 38 hours of community service that was converted from the fine and court costs, which gives us a total of 78 hours of community service that you'll be required to perform during the probationary period. Do you understand that?
I thought we agreed to this 40 hours.
It's 40, but I converted, you had a fine of $200 and court costs of $277. That was converted to 38 hours of community service. And so when you add that 38 hours of community service to the 40 hours of community service, it comes to a total of 78 hours of community service. Do you understand?
Yeah.
Okay. Now, this case will run concurrent, meaning at the same time with your next case, which is cause number 25 CCCR 1825. And you will be required to adhere to follow the other standard terms and conditions of your probation. Ms. Levy, do you understand the state's offer?
Yes, sir.
And the court and adjustments and the findings that the court have made?
Yes, sir.
And do you think that is fair and just?
Yes, sir.
And do you accept it?
Yes, sir.
Okay, Ms. Levy, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Levy, we'll move to your next case. And your next case is cause number 25 CCCR 18525. And Ms. Levy, in this case, I have an information that charges you with the Class A misdemeanor offense of resisting arrest. This information alleges that on or about May 13th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest. Ms. Levy, do you understand what you have been charged with?
Yes, sir.
To this charge, Ms. Levy, how do you plead? Guilty, not guilty, or no contest?
No problem.
Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Levy, I also have before me on my computer a document that is titled misdemeanor plea admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yeah.
On page 2 of this same document, there are 2 sets of initials. First set of initials is on a line next to a box that's checked no contingent, which means no contest. Second set of initials are on a line next to a statement that reads as follows. I do not request discovery. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your second set of initials in this document? On page 3 of the same document, there is a signature above the line that's titled defendant. Is this your signature? And on the next document, that's titled trial court certification of defendant's right of appeal. You recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box is checked, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
And Ms. Levy, before you signed and initialed these documents, did you read the documents?
Yes.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. State.
State offers State's Exhibit 1.
Ms. Levy, the state is offering State's Exhibit Number 1 to be used as evidence in your case. State's Exhibit Number 1 is the first document that I showed you on this tablet. This is the same document that have your initials in these 2 locations on page 2 and your signature at the top of this document on page 3. Is it all right for the state to use this document as evidence in your case?
Yeah.
Okay. No objection. State's Exhibit Number 1 will be admitted. And state, do we have a plea bargain agreement in this case?
Yes, we do, Your Honor. Again, we'd ask for 12 months deferred adjudication, a fine of $300, repayment of court costs, and 40 hours of community service. And ask that this sentence run concurrent with the previous case, cause number 1824.
And does she have a day credit in this one too?
That's correct, Your Honor.
Okay, let's see. What's the court cost? And that.
I didn't have to go with you. Oh, you got me.
Okay,
Thought about it.
Miss. Oh, it's nothing. Okay. Miss Levy. The state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You're required to pay a fine of $300 and court costs of $277. You'll be given 1 day's credit towards your fine and court costs, which will come to a total of $477 instead of $577. That fine and court costs will be converted to 38 hours of community service because the court has previously found that you're indigent. And since you're on probation in the previous case, you're not required to pay a probation fee in this case, and you will not be required to pay a urinalysis fee in this case because you're paying it in the previous case. And the court is waiving the reimbursement fee of $15 that you're required to pay. So therefore, in this case, you don't have anything to pay because the fine and court cost is converted to 38 hours of community service. Now, you will also be required to perform 40 hours of community service. Is that correct?
Yes, Your Honor.
Okay. And
It's
so,
concurrent with the other cost.
yeah, okay. And so you'll be required to perform a total of 78 hours of community service in this case. Do you understand that?
Yes.
Now, this case will run concurrent with cause number 25 CCCR 1824. And you will also be required to adhere to the other standard terms and conditions in this probation. Ms. Levy, do you understand the state's offer?
Yes.
Do you think that is fair and just? And do you accept the state's offer? Ms. Levy, I'll follow the people are in agreement that you have entered into with the state. Ms. Levy, you'll have a seat in that chair, wait for your name to be called. Once your name is called, you go to the window where your name is called. Now, before you do that, I need to inform you that if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to an attorney about the non-disclosure. Okay?
Yes.
All right. So just have a seat in that first chair.
Thank
Wait
you.
for your name to call. You're welcome.
Thank you so much.
You're welcome. Angel Calamino. Court is in session and cause numbers 25 CCCR 1788 and cause number 25 CCCR 1789. Both cases are style of state of Texas versus Angel Calamino.
Yes, sir.
Mr. Calamino, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Calamino, you may put your hand down. How are you doing, Mr. Calamino?
You?
I'm doing fine, thanks for asking. Mr. Calamino, before we get started, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. You waive or give up your right to have a court reporter? Okay. Now, Mr. Calamino, I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
By his name. And Mr. Calamino, I also have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Angel Calamino, on or about June 15th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft of property that had a value greater than or equal to $100, but less than $750. Mr. Calamino, do you understand what you've been charged with?
Yes, sir.
And to this charge, how did you plead? Guilty, not guilty, no contest?
No comment.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Calamino, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line. Actually, there's 2 sets of initials on page 2 of this document. The first set of initials on the line next to a box says check nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
Second set of initials are on a line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document, there's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a pre-bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second set of initials are on a line next to a box that state, I waive my right to discovery. Excuse me, I waive my right to an appeal. Did you place your initials on this document?
Yes, sir.
Now, before you sign and initial all of the documents that I showed you today, did you read those documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Calamino, are you a citizen of the United States?
Yes, sir.
State offer States Exhibit 1.
Mr. Calamino, the state is offering State's Exhibit number 1 to be used as evidence against you in this case. State's Exhibit number 1 is the first document that I showed you on this tablet. This is the same document that have your initials in these 2 locations on page 2, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? No objections. State's Exhibit number 1 will be admitted. And Mr. Calamino, are you a citizen of the United States?
Yes, sir.
Okay. State, you like to offer State's Exhibit number 1?
It's been entered, Your Honor.
Okay. And Mr. Calamino, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay. Mr. Calamino, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what's that agreement?
Your Honor, we'd ask the court for 12 months of deferred adjudication with a fine of $300, repayment of court costs, 40 hours of community service, and a requirement to complete the theft prevention class. And then also Mr. Calamino has 2 days jail credit to go towards his fine and court costs. And for his plea to this cause, the state agrees to dismiss cause number 25 CCCR 1788.
It says 2 days credit. Right? What's the courthouse? 277. Okay, Mr. Calamino, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277, which comes to a total of $577 fine and court costs. You will be given 2 days credit at $100 per day toward your fine and court costs. So it will reduce your fine and court cost to $377 from $577. You also be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $117 a month. Will you be able to pay the $117 each month?
Yes, sir.
Okay. You will also be required to perform 40 hours of community service. You would have to attend and complete the theft class. And let's see. You will be required to adhere to the other standard terms and conditions of this probation. And in accordance with this plea bargaining agreement, the state will be dismissing cause number 25 CCCR 1788. Mr. Calamino, do you understand what you've been charged with?
Yes, sir.
And do you understand the state's offer? And do you think that the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Calamino, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Calamino, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for a non-disclosure, whereby your record will be sealed to the general public. You can talk to an attorney about the non-disclosure. Now, Mr. Calamino, this will conclude your case. You will also get a copy of the judgment and the dismissal from our bailiff. Please stand at the end of the table. Wait for your name to be called. Once your name is called, you'll have a blessed day. Yes.
Yes, I had a question. I live in Houston, Texas. When I do.
Oh, it could be transferred. You talking about one about your probation?
Yes, sir.
Yeah, it could be. You need to tell that to the probation
Right now,
when you go over there, right? And they can transfer it. Okay. Just have a stand next to the bailiff and follow her directions.
thank you so much.
You're welcome. I just sent the I just sent it. That is Rito. This is cause number 25 CCCR 1856, case of South City, Texas versus Status Jamar Rito. You have his waiver, Rito? We need both. I mean, I need a judge's explanation as well. It's not attached?
No, separate for the scheme.
Okay, thank you. Mr. Rito, I have before me. Well, first of all, did I swear you in? Mr. Rito? Yeah, you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Rito, you may put your hand down. And again, Ms. Rito, how are you doing? I'm doing fine, thanks for asking. Ms. Rito, the state is represented by Mr. Samuel Masradian. And Mr. Masradian, how are you doing?
Doing well, Judge. Thank you.
That's good. Now, Mr. Rito, I have before me two documents on paper. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line as titled Defendant? And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding this trial. You recognize this document? And is this your signature on the line as titled Defendant? Mr. Rito, before you signed and initialed these documents, did you read the documents? You understand what you read? And is everything in these documents true and correct to the best of your knowledge? Now, Mr. Rito, before we go any further, I must inform you that you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter to type down everything that's being said. Do you waive or give up your right to have a court reporter? Okay, Mr. Rito, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Rito, it alleges that you, Thaddeus Jamar Rito, on or about March 10th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of marijuana less than 2 ounces. Mr. Rito, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Rito, how do you plead? Guilty, not guilty, no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Rito, I also have a document that is titled Misdemeanor Plea Admonishments. You recognize this document? On page 2 of this document, okay, he missed the spot. He put just a check mark by the discovery admonishment at the bottom.
Yes, sir.
He's supposed to be his initials.
Sorry, I told him to do a check. So,
Okay, thank you. Now, Mr. Rito, the set of initials in 2 locations on page 2. First set of initials is on the line next to a box that's checked no contingent, which means no contest. Did you place your initials on this document? Second set of initials is on the line next to a statement that reads, I do not request discovery. I waive my right to discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials in the second location? On page 3 of this same document, there's a signature above the line that's titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that statement? Now, Mr. Rito, before you sign and initial all of the documents that I showed you today, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Rito, are you a citizen of the United States?
Yes, sir.
State Upper States 1, Your Honor.
Okay, no objection. States Exhibit number 1 will be admitted. And Mr. Rito, is there any evidence that you are currently mentally incompetent to stand trial? Okay, Mr. Rito, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement?
It'll be 6 months deferred adjudication with a $100 fine, 24 hours of community service along with court costs.
What's the court cost?
Tuesday.
Okay, Mr. Rito, state is offering that you serve 6 months deferred adjudicated probation during the 6-month probationary period. You'll be required to pay a fine of $100 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $168 a month. Will you be able to pay the $168 each month?
Yes, sir. Quick question. Would the 2 days that I served, that I did jail time, would that go towards it?
If y'all negotiated that,
I'm willing to let that credit for time served, Your Honor.
you gonna give it credit for it?
Yes, sir.
2
Yes, Your Honor.
days, okay, 2 days. Credit, okay, let me recalculate this.
Sorry.
Actually, no. Okay, now, Mr. Rito, state is offering that you serve 6 months deferred adjudicated probation during the 6-month probationary period. You'll be required to pay a fine of $100 plus court costs of $277. You will be given 2 days credit toward your fine and court costs. In this case, so the fine and court cost is initially $377, but with the 2 days credit, is $177. Okay. You will also be required to pay probation fee of $6 a month, your analysis fee, $15 a month, reimbursement fee of $15. Now, your total monthly installments, instead of being I think 168, it's 128.
Yes, sir.
Okay, would you be able to pay the $128 a month?
Sir.
Okay, you also be required to perform 24 hours of community service and adhere to the other standard terms and conditions of this probation. Now, Mr. Rito, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Rito, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Rito, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure, whereby your record will be sealed to the general public. You can talk to an attorney about a non-disclosure. Now, this will conclude this case. You're gonna stand next to our bailiff and follow her directions. Once you're finished following her directions, you'll be free to go, and you have a blessed day.
Yes, sir. You too.
Thank you. Okay. Set. Got mail. What happened to these people? She said he was here. Oh, this person hired Adams. Donald Randall. Miss,
Randall?
Jefferson County Court of Law is back in session. The court is in session in clause number 25 CCCR 1792. Case of style of the state of Texas versus Amy Michelle Mayo. Amy Mayo was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's better call the name of Amy Mayo at the courthouse door. Amy Mayo did not appear. Amy Mayo has not appeared in court since the court has been in session. The time now is 1:07 p.m. on today's date of September 23rd, 2025. Ms. Bailiff, would you please call the name of Amy Mayo at the courthouse door?
No response, Your Honor.
Okay. Amy Mayo's name was just called at the courthouse door. Amy Mayo did not answer. A reasonable time has passed to give Ms. Mayo an opportunity to appear in court. She has not appeared in court. State, do we have a motion? That motion will be granted. Amy Mayo's bond will be forfeited, and a warrant shall be issued for her arrest in clause number 25 CCCR 1792. And this will conclude the calling of court's arraignment docket on today's date, September 23rd, 2025, in County Court at Law number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Prosecutors, you're excused, and everyone, please have a blessed day. You're welcome.
You put it on top.